How to conduct a DPIA. In another video, we identified personal data processing activities that require a Data Protection Impact Assessment, or DPIA for short. Once the need for a DPIA has been established, many humanitarian organizations use a DPIA template to record the organization's DPIA process and outcome. Although each organization's DPIA process and template may differ, having a structured framework makes the process easier. Let's explore a hypothetical processing activity to illustrate how a DPIA is conducted. Aid First, a humanitarian organization, has partnered with Digital Corporation, a software company, for the use of the company's Analyze platform to collect, process, and store the personal data of women living in a remote community in Cape Ruvania. Since sensitive personal data may be included in data processing, a DPIA was conducted using the organization's template to ensure that data subject rights are protected. The notes and questions related to data protection served as a guide for what should be considered in the assessment. The first section of the DPIA template explains the proposed processing activity. Aid First starts with the goals of the projects and how the data collection software Analyze contributes to the achievement of the goals. The next section is divided into subsections on the nature, scope, and purpose of processing, respectively. First, Aid First describes how and why the organization plans to use the personal data. This is followed by a description of what the processing activity will entail. Aid First used this section to record data about the subjects, the specific type of data to be processed, and how data will be used. The internal and external factors that may affect results are logged next. Aid First outlines the categories of data subjects whose data will be processed, with a special consideration given to the vulnerability of the data subject. Aid First must also take into consideration whether the processing will make it easier or more difficult for the data subject to exercise their rights, as well as the security measures. The last subsection is where the specific purpose for processing is recorded. Here, Aid First described the specific purpose of the processing and whether the processing activities are necessary and proportionate to the purpose. The third section records the consultation process. Aid First used this section to document the consultations with all relevant stakeholders. The section that follows guides the conduct of a proportionality analysis to validate that all or any of the personal data is needed to fulfill the objectives. Aid First demonstrates data protection and compliance in this section by documenting the legal basis of the processing, as well as the other measures put in place to protect data and the data subject's rights. Section 5 summarizes the results of the risk assessment. It may not be possible to eliminate all risks, but they should be documented, and any residual risks need to be considered and, if appropriate, accepted. In this section, Aid First logged 4 risks identified using a risk matrix, which considers both the likelihood and severity of any impact on individuals' rights and freedom. Related planned security measures and mechanisms of handling risks to ensure protection and demonstrate compliance were also included. Finally, a section for the sign-off from relevant stakeholders and for recording outcomes complete the DPIA document. To conclude the DPIA, Aid First secures stakeholders' sign-off on the residual risks and measures defined during the assessment. The DPIA will be monitored and reviewed periodically for accountability of those involved. The given example helped us visualize how to use a DPIA template. However, the DPIA process goes beyond filling out a document. It is about giving a clear picture of the risks involved in processing data, such that interventions may be defined and implemented. It is a flexible and scalable document that, if regularly reviewed and updated, assures stakeholders that the organization takes data protection seriously.
Data controllers and data processors. Under most data protection laws, the data controller has the overall responsibility of protecting personal data and safeguarding data subject rights, whereas the data processors must have organizational and technical measures to ensure data protection. The data controller determines the why and the how of data processing and ensures that the activities comply with applicable laws and regulations. On the other hand, the data processor performs manual or automated collection, recording, organization, storage, adaptation, use, disclosure, or other processing activities on behalf of and upon documented instructions of the data controller. Depending on the nature, purpose, and manner of processing, an organization can either be a controller or a processor. For example, when your organization collects information from photographs or videos taken from the field and stores them in a third-party site for hosting and sharing, your organization acts as the data controller, while the third-party site assumes the role of the data processor. Because these photographs and videos are considered personal data, these are subject to data protection legislation. Your organization must have a separate agreement with such third-party partner to safeguard data processing. Your organization may share with another organization a common objective or purpose for data processing, or may process the same set of personal data. In these situations, your organization acts as a joint controller, in whole or in part, with this organization who is also a data controller. This is also true if the organizations have common information management rules or have designed the process together. There may be some cases in which your organization shares personal data with another controller, but each controller processes data exclusively for their own specific purposes. This relationship is called controller-to-controller relationship. In other instances, your organization may act as a data processor. This is true when it does not make decisions regarding data processing and simply processes information on behalf of another organization and will not continue processing the data for its own purpose. Understanding the role of the organization in any specific processing activity is essential for compliance of both parties.
Data disclosure agreements. For any project or activity that requires sharing of personal data, the GDPR and other protection laws require a data disclosure agreement to regulate the purpose and scope of processing. If data is shared internally within the organization, due diligence is needed to ensure that there is a legitimate purpose for sharing data, the consent of the data subject has been obtained, and the data being shared is kept to a minimum. In such instances, check the existing organizational policy if a data disclosure agreement is necessary. If the organization is working with another party, for example, a consortium or implementing partner, a local government, an auditor, a consultant, or a software company, and the personal data will be transferred between them, a written data disclosure agreement needs to be signed to govern these activities and ensure compliance with relevant laws and regulations. Data disclosure agreements are usually added as annexes to the principal contract between the parties and sets out the details of the processing. The following are the 4 commonly used agreements. Data sharing agreements between 2 or more data controllers who intend on sharing personal information routinely and regularly between themselves. Data processor agreements wherein your organization acts as a data controller who contracts an outside data processor third party to undertake a task that involves the processing of personal data on its behalf. Subprocessor agreement between a processor and subprocessor who processes personal data on behalf of the controller. Joint controller agreement between two controllers who jointly determine the purpose and means of processing. Transfer of personal data to countries outside the EU or to countries who have not received an adequacy decision carries additional risks to data subject rights due to a possibly lower level of data protection in the destination country. Data controllers must ensure that there is a valid legal basis for the transfer and all relevant GDPR obligations, including the provisions in Chapter 5. Additional safeguards include completing a Transfer Impact Assessment, or TIA for short, incorporating the standard contractual clauses into the agreement, and ensuring that adequate technical safeguards are agreed upon. By understanding the role of an organization in data processing, the necessary safeguards, including the appropriate data disclosure agreement, may be put into place to ensure that the risks to the data subject have been considered before any data is shared.